Just some house rules. I will deal with 3 different roles today. We're going to start with a judgment that I will hand down and read in certain portions of the judgment. Thereafter, our admissions. Then we'll move into the motion court role set down for today. Everybody got the same invite for 8:30. I will then deal with the divorces on the motion court roll, then the unopposed applications, whereafter I will adjourn and put on my criminal robes and then proceed with a criminal trial. We are sitting in the High Court in Thembalethu, as I am currently working from here, and I'm attending to both the civil circuit as well as the criminal circuit. I'm going to call the first case. It is the judgment that I'm going to attend to, whereafter I will ask the counsel involved in that just to place themselves on record. It's the matter of, it's case number 8500 of 2022. It's the matter of the Public Protector of South Africa and the Speaker of the National Assembly as the first, the chairperson of the Section 194 Committee, the second respondent, the President of the Republic of South Africa as the third respondent, and from 4th to 17th respondents are all the political parties represented in the National Assembly. So, Mr. Mpofu, I can see you are there.
Please, good morning, my lord, and everyone. Yes, my lord, I confirm that I appear for the applicant together with my learned friends, Mr. Shabalala and Ms. Makape.
Yes, Mr. Breitenbach, I can see you there.
My lord, good morning. Yes, I appear for the first and second response. I'm not sure whether my juniors have managed to make this attendance. If they haven't, I apologize for their absence.
Thank you. Ms. Pillay, I saw you were on.
Yes, good morning, Judge. I appear on behalf of the President.
And then I have not seen Mr. Badlender on, but I saw Mr.
Lord,
on this
yes,
morning.
Lord. Mr. Badlender sends his apologies. He's unfortunately not available, but I appear on behalf of the Democratic Alliance, the fifth respondent.
Thank you. Anybody else that's on Mr. Masuku's team? Mr. Masuku's team on? Mr. Similani, maybe? Before I start with the judgment, just some introductory remarks. I caused the invitation to be sent out yesterday to all the parties on an email indicating physical appearance, for the simple reason that I am sitting out in the Southern Cape and it wouldn't have been feasible to ask anybody to attend formally in person in court. The judgment was prepared by myself and my 2 colleagues sitting with me. The draft circulated amongst us and finally edited during the course of the week. We have prepared and scanned in PDF form the judgment. The parties will note that one of my colleagues had signed on my behalf, as the originals are in Cape Town and will be placed on the file there, and I will only return to Cape Town at the end of next week. It's for that reason that one of my colleagues had signed the original on my behalf. However, I have decided as the presiding judge of the panel to deliver the judgment myself in open court, as well as on the virtual platform to accommodate everyone. I'm also aware that there were developments last night or late afternoon after we had set down this matter for the judgment to be delivered. In the judgment, we only deal with the facts that were available to us at the time of the hearing and until the final amendment of the notice of motion. I therefore will proceed with the judgment in this matter, and I will only read certain portions of the judgment, which is contained in a 46-page typed judgment, of which I will only read certain paragraphs in the judgment for purposes of the handout. The judgment is marked to be delivered by email to the legal representatives of the parties on the 10th of June, 2022, and in the email that we've sent out yesterday, you would have noted that I instructed the registrars to release the judgment as soon as I have handed it down formally in open court. So this is a judgment of the court, authored by myself, Erasmus J, with my colleagues Delamo and Villa. As the introduction, this is a unanimous judgment of the court. This matter concerns one of the core values of our constitutional framework. The Public Protector is a Chapter 9 institution that performs a vital function to strengthen our constitutional democracy by holding the executive and legislative branches of the state to account. The Public Protector reports to the National Assembly, which in turn has a constitutional obligation to hold the Public Protector to account under certain circumstances and processes. This is an opposed application for an interim interdict, interdicting the implementation of certain crucial and significant executive and legislative functions. This application therefore strikes at the very heart of our young democracy. This is because the applicant seeks an order impeding the parliamentary respondents from continuing with their processes of deciding whether or not to remove Advocate Mkhubane from her office. Whilst the notice of motion refers to the applicant as the Public Protector of South Africa, this matter concerns the incumbent, Advocate Mkhubane, who sought the following relief. We are only seized with Part A of the relief sought. Pending the finalization of Part B, granting an interim prohibitory interdict and or mandamus for an order in the following terms. I will not deal with the urgency issue. 1.2 thereof, the Speaker and of the National Assembly are hereby prohibited from authorizing commencement and or performance of any functions of the committee established in terms of Section 194 of the Constitution for the removal of the applicant. 1.3, the Speaker is hereby mandated to withdraw her letter to the President dated 10 March 2022. The President is prohibited from taking any steps pursuant of the suspension, Section 194, sub 3 of the Constitution. 1.5, the President is mandated to withdraw his letter to the applicant dated 17 March 2022. I note that in a footnote to the judgment, that the notice of motion was amended after the hearing of the matter. 1.6, the first to the third respondents are prohibited from taking any further steps or performing any act aimed at commencing and or proceeding with the process envisaged in section 194 of the Constitution. Further and alternative to the relief sought, appropriate, just and or equitable relief in terms of section 38 and or 172 of the Constitution. And then an alternative to the first prayer, under 2, in terms of Rule 45, capital A, alternatively section 172(1)(b) of the Constitution, suspending the operation and execution of paragraph 118A sub 2 of the order of this court in case number 2107 of 2020, as amended by the Constitutional Court, pending the finalization of Part B and or the two applications filed on 11 March 2022 and 11 May 2022, respectively, in the Constitutional Court under case numbers CCT 257 of 2021 and 259 of 2021, and then an attendant relief for I shall relief sought under paragraph B. I go to paragraph. One of the core issues that require our scrutiny is that of the answerability of the various appointed actors within our constitutional law to hold each other to account. While it is indeed so that the office of the applicant performs a vital role in holding the executive branch to account, the incumbent to the former must also be held accountable and answerable. As a matter of pure logic, it must be so, because independence ability may be a ticket that may lead to the abuse of power. I turn to a portion of paragraph 10 of the said judgment. For purposes of convenience, it is recorded that the fifth respondent is the Democratic Alliance, and the respondents supportive of certain relief claimed by the applicant are the United Democratic Movement and the African Transformation Movement, respectively. Paragraph 11, constitutionally speaking, the public protector is answerable to Parliament. The Constitution grants the National Assembly the power to remove the public protector from office. This by a 2/3 majority. The Constitution indicates that this power must be exercised diligently and without delay. It must be so that the administration of justice of being brought into disrepute in the event that the process falls to be unnecessarily delayed. We continue on various issues in the judgment, and then at paragraph 20, we state the following. On the day before the matter was scheduled to be heard before this court, the lead counsel for the parliamentary respondents received a short message service, in inverted commas, from a then unidentified person, which indicated as follows. I quote, within the quote, "Hello, Advocate Breitenbach. Ray, the public protector case tomorrow. I have it on very good authority that the Concourt has declined to hear the public protector's rescission application. The decision will be made known sometime this coming week, but not later than Friday. I thought I'd just share this with you on a strictly confidential basis. Thanks," close quote. As a portion of paragraph 21 of the judgment, we state, debate and discussions followed, and essentially by agreement, this court postponed the hearing of the matter that was scheduled for hearing on the 18th and 19th, for hearing to the 18th and 19th of May 2022. The court was advised as follows, I quote, "There has been an unfortunate development relating to the application in the Constitutional Court brought by the applicant for rescission of parts of the Constitutional Court judgment of 4 February 2022. The postponement is sought inter alia see clarity about. It was further agreed that a letter jointly drafted by the parties to the Apex Court informing it of the message received and the content thereof. This court declined to be a party to this letter, but voiced no objection to same being sent to the Apex Court. We were given to understand that this joint letter was subsequently sent by the attorneys representing the applicants to the Apex Court. At paragraph 26 of the judgment, I quote, I read a portion thereof. On the 6th of May 2022, the Apex Court handed down an order dismissing the rescission application piloted by the applicant and also the application for direct access at her instance. The Apex Court ruled in the following terms, I quote, "The Constitutional Court has considered the application for direct access and rescission. It has concluded that there is no need for directions to be issued in terms of Rule 18 sub 4, calling for written submissions and or answering affidavits. The court has concluded that the rescission of the judgment, there are also no exceptional circumstances that warrant the rescission of the judgment. Therefore, the court has concluded that the application should be dismissed as no case has been made out for rescission. The court has concluded that the application for direct access should be dismissed as no case has been made out for direct access. The court has decided not to award costs." Close quotation. At paragraph 29 of our judgment, the following issues require our attention. A, the striking out application. B, whether the applicant is entitled to an interim interdict pendente lite. C, whether res judicata or issue estoppel is relevant. And D, if any of the National Assembly rules support any basis for the relief contended for by the incumbent. Paragraph 30, under the heading Interlocutory Applications, we state the following. There were a host of interlocutory applications filed. In addition to those filed prior to the hearing of the matter on the 18th and 19th of May 2022, the applicant filed a post-hearing application to amend the relief sought in the notice of motion. The only interlocutory application that was contentious in any manner related to the application by the applicant to strike out parts of the unsealing papers of the first, second, and fifth respondents in terms of Rule 6, sub 15 of the Uniform Rules of Court. That application remained opposed. Under paragraph 30, I read a portion thereof. We are of the view that insofar as this issue relates to the first respondent's affidavit, the following: A, the impugned passages are not in dispute, and B, they are already in the public domain and of significant relevance to the issues to be decided. At paragraph 32, in connection with the application aimed at the affidavit of the third respondent, in brackets the President, it related to A, the various pending investigations in which the applicant allegedly failed to make a full disclosure, and B, the timing and status of the investigations which go to the question of the avert conflict of interest. We do find it rather curious that the applicant moved to strike out documents that originated from our own office. Paragraph 33. We hold the view that there is no merit in the application for the striking out of any of the information as contended for, and that it is hard to discern why the applicant would take up the position that she did, having regard to some unfortunate emotional outbursts and intemperate language put forward in her own affidavits. Paragraph 34. Having regard to the Apex Court's dismissal of the rescission application, Advocate Mqwebani nevertheless again sought to challenge and set aside the order granted on the 6th of May 2022 for the following reasons. A, that it is no longer feasible for the proceedings of the inquiry committee to continue. B, that there is a jurisdictional bar to the present application pending the outcome of an investigation, and C, the true and final state decision of the rescission application is unknown, in inverted commas, pending the outcome of the investigation. Paragraph 35. In the most recent application, the new rescission application piloted by the applicant to the Apex Court, she seeks the following relief, namely A, an order declaring the conduct of the Chief Justice authorizing the release of the order dated the 6th of May 2022, in brackets, prior to the outcome of the investigation, to be invalid. B, an order declaring the request by the first respondent for the urgent disposal of the rescission application to be invalid, and C, an order that the failure to further respond to the applicant's letter in this connection is to be declared to be invalid and unconstitutional. At paragraph 36, in summary, the applicant seeks a further order from the Apex Court to rescind and reconsider the prior order dated 6 May 2022. In the further alternative, an order is sought to develop the common law so as to cater for the new rescission order sought on the basis of alleged irregularity and criminality, which taints the legitimacy or legality of the order and negatively implicates the impartiality of the decision-making persons or institution involved therewith. Simpliciter, the applicant requests that the final order granted by the Apex Court be set aside yet again by way of another rescission process. I then move on to the parliamentary challenges, and I will read from paragraph 38 and 39 of the judgment. The case against the parliamentary respondents is buttressed by the argument in connection with the pending new rescission application, which the applicant says prevents the Impeachment Inquiry Committee from progressing with its work. The inherent problem with this argument is that any application for rescission does not automatically suspend the operation of a court order. Put in another way, it legally has no effect on the execution of a court order. The authorities on this latter issue are crystal clear that the mere launching of an application for rescission does not automatically suspend the operation of the underlying order. This position in law has since been confirmed in numerous judgments. If this was not the case, as a matter of logic, it would have a result that the mere filing of an application for rescission, even a groundless one, would impede the operation and execution of court decisions and court orders. Paragraph 39, I will only read the first sentence of the paragraph. The rule of law stands to be completely eroded and undermined if this position was to be accepted. I turn to the legal issues of res judicata and issue estoppel, and I will read from certain paragraphs, only portions thereof, for purposes of delivering this judgment. Judgment will be available immediately after. Paragraph 45, issue estoppel applies where an issue of fact or law was an essential element of a prior final judgment. The issue cannot be revisited in subsequent proceedings before another court, even if a different cause of action is relied upon or different relief is claimed. That having been said, it is indeed so that our courts have recognized that a strict application of issue estoppel could result in unfairness in some unusual circumstances. I read a portion of paragraph 46. The nature of the issues before us in this application is not in any doubt. By prior decision of this full court, the full court of the Western Cape Division, no difficulty arose in circumscribing the issues before them, and they contended, and they correctly defined the issues that came before them. The applicant deemed inquiry. Paragraph 50 of the judgment. There is absolutely no doubt that this doctrine has been fully assimilated into our law. The doctrine applies equally to pure claims of res judicata and to claims based on issue estoppel. When the applicant went to court to challenge precisely this issue in a prior application before a full court of this division, it must be so that she was required to put forward a case. Paragraph 51. By doing the applicant euthanized connection with the issue of challenges to be held accountable by the Impeachment Inquiry Committee and to attempt to bring a halt to this process. Additional alternative complaints, in brackets, in the form of the new pending rescission application for the determination of the same issues, cannot be raised in subsequent proceedings on the same issues in circumstances where the applicant's first attempt failed on the same issues. I turn to paragraph 54 of the judgment. The issue for the purposes of issue estoppel is a totally discrete concept from a cause of action or a remedy. It is precisely for this reason that Advocate Mkhubani is not permitted to pioneer in later proceedings in respect of an issue, a ground that she failed to raise in her original proceedings. I read a portion of paragraph 55. To allow this would undermine the finality of judicial decision-making and cast doubt over the trustworthiness of judicial decisions. Turn to paragraph 58 of the judgment. It seems abundantly clear to us from the decided authorities in connection, in brackets, that the issue of the continuation of the impeachment process, together with the issue of a possible breach of the sub judice rule, has been finally determined. And in a footnote, we give references to the cases. Further, where the parliamentary respondent should be precluded from continuing with the impeachment process until Advocate Mkhubani's challenge to the constitutionality of any of the rules, in brackets, as set out in an initial rescission application, has also been finally determined. I turn to paragraph 62 of the judgment. What remains for us is to deal briefly with the principle of res judicata. This is aimed at preventing a multiplicity of actions based upon the same cause of action and ensuring that there is an end to litigation. Put in another way, this is a legal principle that is aimed at avoiding an obstructive approach to litigation. Paragraph 63, the present application before us seeks to resuscitate Advocate Mkhubani's previously failed application by preventing the parliamentary respondents from continuing with the impeachment process until all her challenges have been exhausted and pursued by way of a second application for rescission. This is, in our view, untenable and legally unsustainable. Under the next heading of the judgment, we have a long discussion of the right and the process for interdicts, and I will only read out, starting from paragraph 75 now of the judgment. In the present application, Advocate Mkhwebane seeks to interdict the parliamentary respondents from continuing with an impeachment process, pending the outcome of litigation for final relief. No doubt the previous full court applied the above-named principle correctly. The interim interdictory relief sought in the previous proceedings is indistinguishable from the interim interdictory relief sought in the present case. The only possible way we can differ from this finding is to hold the view that the previous full court was wrong. Not only was the previous full court, in our view, not wrong, but was unequivocally correct. I go to page 80, paragraph 82 of the judgment, where we state, we are further of the view that on any legal test properly applied, Advocate Mkhwebane's application falls overwhelmingly short of the requirements for any ordinary interdictory relief. We say this because Advocate Mkhwebane has, in our view, not demonstrated even a prima facie right for an interdict, preventing the parliamentary respondents from continuing with the impeachment process, pending our now new second rescission application. Paragraph 83, that having been said, what obviously remains of utmost importance is the fact that the public interest will not be served by the granting of an interdictory relief in these peculiar circumstances. Further, an interim interdict will prevent the parliamentary respondents from performing their role of determining whether Advocate Mkhwebane should be impeached or not. Paragraph 84, even if we are wrong on the issue of a prima facie right, if the third respondent, that is the President, indeed elects to place Advocate Mkhwebane under a precautionary suspension, Advocate Mkhwebane will be entitled to seek judicial review of the decision to suspend her from office. Advocate Mkhwebane will be granted the luxury of having a more than reasonable and fair opportunity to exonerate herself. Paragraph 87, we must emphasize that there exists a strong public interest in the continuation of the impeachment process. It's a matter of logic. There is serious prejudice against the separation of powers and the public interest in the event that the impeachment process is not concluded timeously and without inordinate delay. This will happen if the interdict is granted, and this overwhelmingly outweighs any harm that Advocate Mkhwebane will suffer. If the interim interdict is refused and she is ultimately successful with her second rescission application. I turn to paragraph 90 of the judgment, and this is covered under the heading the Presidential Challenges. Advocate Mkhwebane seeks to prevent the third respondent, the President, from deciding whether to suspend her or not. For this relief, she advances that A, the Impeachment Inquiry Committee has not yet commenced with its proceedings. B, accordingly, the third respondent has no power to proceed with the process to suspend her. C, the third respondent is conflicted because the applicant is considering complaints against him. And D, therefore, somebody else must decide whether to suspend Advocate Mkhwebane. We have a long discussion on that issue, and when I decided what portions to read out into the record, I thought it would just be necessary to refer to two more issues in this regard. I therefore go straight to paragraph 127 of the judgment. It starts with, moreover, Advocate Mkhwebane takes the position that she will suffer constitutional harm because the process that will unfold against her will primarily be based on the report of the independent panel, which she advances is unconstitutional. The Apex Court has dealt comprehensively with this issue, and it cannot be resuscitated in this hearing. Paragraph 1 to 8, a portion thereof. Finally, on this issue, we hold the view that there are a number of alternative remedies available to Advocate Mngubane other than to prevent the third respondent from rendering a decision in connection with a possible suspension. Paragraph 136 of the judgment, we state, no doubt, serious prejudice against the doctrine of separation of powers and the public interest will endure in the event that the inquiry committee is prevented from continuing with its work in view of the trenchant judicial criticisms against Advocate Mngubane. I will read in the full conclusion of the judgment starting on page 41 from paragraph 137 of the judgment. All the complaints against the impeachment inquiry rules have now been finally euthanized by the judgment of the Apex Court. In an attempt to resuscitate these objections and complaints, the applicant chartered an so-called appeal, because we put it in inverted commas, against this decision, formulated as an application for rescission. The process in itself may very well undermine the legitimacy of the Apex Court. In our view, a strong signal needs to be sent that the judgments handed down by the Apex Court are final, need to be obeyed, respected, and cannot be circumvented through the device of a rescission application. And we refer to authorities in this regard. 139, in the interim period, in brackets, after the judgment delivered by the Apex Court, the parliamentary respondents were unfazed and continued with their work of the impeachment inquiry. No doubt, this triggered the correspondence to the applicant from the third respondent to the effect that he was considering suspending Advocate Mngubane, together with the request to her to make representations why this should not occur. In response to this, I'm at paragraph 140, Advocate Mngubane claims that the third respondent is conflicted because of the investigation of certain pending complaints or offices addressing against him. Moreover, it is contended that even though the impeachment inquiry committee was actively preparing for the now scheduled hearings, it had not commenced with its proceedings. 141. Again, as an accommodation, the third respondent agreed to delay his decision on whether to suspend Advocate Mngubane so that she would be presented with an opportunity to challenge his right to do so and also the right to proceed with the impeachment inquiry. 142. In the result, this court was enjoined to consider an application that, in the main, seeks to prevent organs of state from exercising powers specifically assigned to them by the Constitution. Preventing the exercise of legislative or executive power treads deep into the heartland of these branches of authority, and accordingly, it is strike law that we can only do this in very clear cases. But this case is, and by no means, a clear case to the benefit of the incumbent, of the applicant. We then deal with the costs and the order, and I will only read out certain paragraphs as was stated in the judgment. I turn to paragraph 149 of the judgment. In all the circumstances of the matter, we hold the view that a personal costs order in this matter is warranted for some of the reasons set out in this judgment. We are however not persuaded that any costs order should be granted on a punitive scale. Paragraph 150. Whilst we do have deep suspicions about the alleged conduct of Advocate Mngubane during the course of this litigation, we simply cannot visit this conduct, absent further evidence, to the threshold adequate for a punitive costs order. 151. That having been said, it must have dawned on her shortly after the refusal of the rescission application handed down by the Apex Court that the shields that she had raised to the inquiry process and the alleged bias of the third respondent were doomed to failure. It is for this reasons that a portion of the costs awarded in this matter will be awarded against Advocate Mukebani in a personal capacity. And then at paragraph 154, in the result, the following order will be granted. 1, that the application to strike out is dismissed. 2, that the main application is dismissed. 3, that each party shall be liable for their own cost, except that the public protector shall be liable for the cost of the fifth respondent, including the cost of 2 counsel where so employed, up to and including until the 6th of May 2022. Paragraph 4 of the order, that Advocate Mukebani in a personal capacity shall be liable for the costs of and incidental to this application on a party and party scale, including the costs of 2 counsel where so employed, as taxed or agreed from the 7th of May 2022 and thereafter. That is the order of the court, and it was agreed to and concurred with by my brothers Delamo J and Villa J. The judgment was date stamped by myself on yesterday's date and has now been handed down formally.
As the court pleases, my lord, I do want to make 1 or 2 remarks, but let me maybe get my learned friends to acknowledge.
Yes, certainly, Mr. Breitenbach.
As the court pleases.
As the court pleases.
As the court pleases, Lord.
Yes, as I've indicated, Mr. Mpofu, I have authorized the registrar, who is online at the moment in the office, that they can now press the send button and distribute the judgment.
Yes, my lord.
We've already, yesterday during the course of the day, we already prepared a draft email, and I've indicated to them the moment I'm done, they can press the send button.
Yes, my lord, we are indebted to your lordship so that we get the full reasons. Yes, my lord, thank you. I just wanted to say that, well, to make 2 quick remarks. The first one is that I'm sure maybe your lordships did not notice that the strikeout application was actually not pursued, the one that you dismissed now. But the real issue is about the cost order. Our instructions before that were that we would seek to accelerate the hearing of Part B rather than pursuing this, because it would seem that this judgment is based mainly on the fact that it was an interim order, which it obviously was. But because of the cost order, my instructions might be different. But yes, I just wanted to place that on record, that what will happen is to ensure that Part B is heard before the so-called impeachment process starts, as court pleases.
Thank you, Mr. Mpofu. Any other comments from any of the other counsel involved? If none, then you may be excused from the proceedings, and anybody else that doesn't have an interest in the rest of my role, you may also be excused. I'm going to continue with my normal role.
Thank you, my lord.
Can I just ask?
Thank you.
Thank you, my lord.
Can we stop the recording now, and then we'll start